Namaste. Welcome to the Pan India Legal Literacy, Legal Awareness and Legal Education Program, flagged off by the Department of Justice, Government of India, and effected by Center for Environmental Education, Research and Advocacy at National Law School of India University, Bangalore. Myself, Diana, will be talking on the topic of consumer and the law in India. The commercial market in India had witnessed great changes in the wake of digitalization that further influenced the market transactions. Consequently, the Consumer Legislation of 1986 had to be replaced with the Consumer Protection Act of 2019. Today, we also have the Consumer Protection E-Commerce Rules of 2020 and the Consumer Protection Consumer Dispute Redressal Commission Rules of 2020 as the framework of consumer law in India. In legal parlance, a consumer would mean every person who obtains goods or avails services for a consideration. But if such a person obtains those goods or avails those services for resale or for a commercial purpose respectively, then he does not fall within the category of a consumer in India. Every person who is a consumer is granted some explicit rights under the law here. They are the right to safety, the right to choose, the right to be informed, the right to be heard, the right to seek redressal, and the right to consumer education. The new legislation has some key features that are aimed at boosting consumer welfare in India. One such is the concept of product liability, which imposes a liability on the product manufacturer, product seller, or the product service provider in case of harm that is caused to a consumer by the use of a product or availing of a service. Here, harm would mean other than damage to property, injury, illness or death, or emotional distress or mental agony arising out of such harm. But if the harm is caused due to loss of the product itself, or due to breach of warranty conditions, or if the harm is commercial, consequential, or incidental in nature, then it would not constitute harm within the meaning of the law. A product manufacturer becomes liable if there is a manufacturing defect in the product, or if the design is defective, if the product is different from that mentioned in the specifications, if the product does not conform to express conditions provided, or if it does not contain adequate instructions or warnings of use. On the other hand, if it is a product seller who had substantial control over the product from the designing to the labeling stage, makes a modification or alteration to the product which thereby results in the harm, then liability can be imposed on him. Such a product seller will also be liable if he makes a warranty independent of that made by the manufacturer and the product does not conform to those express warranties. Liability can also be imposed on the product seller if the manufacturer's identity is not traceable or if he does not disclose it, and in case of assembled goods, if he has failed to exercise reasonable care in maintaining, inspecting, and assembling those goods. Now, if you come to a product service provider, he is liable for providing a deficient service. Here, deficiency would be meaning a fault, a shortcoming, or inadequacy in the nature, quality, and the manner of performance of the service. If such product service provider purposely withholds an information which thereby causes the harm, or does not provide adequate instructions or warnings for use which results in the harm, then he is liable. But there is no absolute liability under the clause of product liability. If the consumer himself was under the influence of alcohol while using the product, or if he himself has misused, modified, or altered the product while the harm was caused to him, and if the product was used in workplace after issuing sufficient warnings to the employer, or if the product in question was used in another end product which caused the harm, or if the consumer has used the product without expert supervision, then no liability can be imposed either on the product manufacturer, product seller, or the product service provider. Taking into account the looming presence of e-commerce entities in the market, the Consumer Protection E-commerce rules of 2020 were framed under the Consumer Protection Act of 2019. Rule 5 in particular mandates, please note the rule is mandatory, that every e-commerce entity must set up a consumer dispute redressal mechanism, state their country of origin, acknowledge the receipt of every complaint within 48 hours, and also provide redressal for such complaints within a period of 1 month from the date of receipt. Now, the subject matter of such harm or problem can be an unfair trade practice, deficiency of service, and even an unfair contract. Here, unfair trade practice can be anything from disclosing personal information provided by the consumer, refusing to take back defective goods, refusing reimbursement of such defective goods or deficient services within a period of 30 days or the amount time stated in the bill. Now, compensation can be sought merely for a harm that is caused by the use of a product or service, and not just product liability in civil courts. Earlier, it was possible to file a complaint only in the place where the seller or defendant resided. Now it is possible to file consumer complaints in places where the consumer is working or residing. The new legislation makes applicable all rules of direct selling to e-commerce in the market. This is due to the flurry of netizens in the wake of digitalization of the Indian economy. There is an adage in law that justice delayed is justice denied. The new legislation on consumers have provided the mechanism of mediation as a means of alternate dispute resolution. Mediation can be done without resorting to the consumer courts. If the mediation is successful, the terms of the agreement will be written down by a qualified mediator decided by the parties themselves. If the parties fail to decide on a mediator, then the concerned commission will nominate a person as a mediator. At no point of time, the mediation fees will exceed Rs 2,000, which will be borne by the respective states or the union territories. But the cost of production of witnesses and documents have to be borne by the parties. In case the mediation is unsuccessful, then the concerned commission will pass a suitable order within 7 days from the date of receipt of the settlement report. But there are certain limitations to mediation. Mediation cannot be resorted to in cases of medical negligence, which results in grievous injury or death of the consumer, in cases for compounding of offenses, in cases involving fraud, forgery, fabrication of documents, criminal prosecution, public interest litigation, and impersonation. Also, if a case is pending before a commission and the commission itself is of the opinion that the case has no scope for settlement, then mediation cannot be resorted to in such cases. Yet another provision for speedy disposal of cases was to enhance the pecuniary jurisdiction of the National Commission in the disposal of complaints. The new consumer legislation, the Consumer Protection Act of 2019, has set up a regulator known as the Central Consumer Protection Authority. This central authority is equipped with an investigation wing headed by the Director General. The central authority has the powers to inquire and investigate cases on its own accord suo motu, or on the direction of the central government, or on receipt of a complaint. This regulator also has the powers to refer matters to other regulators like the district collector or the Director General of Investigation in case it is satisfied that there is a prima facie violation of consumer rights, unfair trade practices, and false and misleading advertisements. The central authority can conduct an inquiry, after which it can cause an investigation to be made in the matter through the Director General of Investigation or the District Collector, call upon these other regulators as well, and also direct them to produce documents or records in their possession. The powers of the central authority also extend to goods. They can pass orders for recalling of goods or withdrawal of services which are dangerous, hazardous, or unsafe, order for the reimbursement of the price of such goods or services, and also discontinue any practices which are unfair or prejudicial to the public or to the consumers. The Central Consumer Protection Authority can impose directions and penalties against false and misleading advertisements. It can also issue prohibitory orders on the endorser up to a period of 1 year in the first instance and up to 3 years in case of violation of the first prohibitory order issued. Any person who is aggrieved by an order of the Central Consumer Protection Authority may file an appeal before the National Commission within 30 days from the date of receipt of such order. There have been a series of consumer issues that have been addressed by the courts. We have all paid for carry bags with logo of retail stores at one point of time. When the matter was disputed in the courts, it was held that making a consumer pay for a carry bag with the store's logo is exploitation of the consumer by making him advertise for the store and therefore an unfair trade practices. The retail stores were asked to reimburse the cost of the carry bags. Now, there are airbags in your vehicle and they are supposed or expected to deploy during a collision. A person unfortunately suffered head, chest, and dental injuries when the airbags in his vehicle did not deploy during the collision. The Supreme Court ordered the company to pay compensation as the car fell short of its expected quality. Incidental to this is a fact that there are a class of vehicles in which airbags do not deploy unless the passenger has worn the seat belt. Also, the rules framed under the Motor Vehicles Act mandate that every passenger in the front seat next to the driver's seat and also in front-facing rear seats have to wear the seat belt, failing which a fine of ₹1,000 can be imposed on them. Recently, the Central Consumer Protection Authority passed an order stating that levying service charges by restaurants in any form on consumer is an unfair trade practice. So if a restaurant slaps you with a service charge, you can file a complaint with the Consumer Commission through the online portal e-Dhaki or with the district collector, who after making an investigation into the matter will refer the matter to the Central Consumer Protection Authority. There was a case before the National Commission. Imagine you have spent all your life's earnings on buying a villa, and the builder or the seller insists that the key of the villa will be handed over to you only if you sign a paper stating that the villa is in a livable condition when it is actually not so. Now, you don't have to sign such a paper. The seller or the builder in the instant case was asked to pay back the amount paid by the consumer with interest, and also compensation was awarded for mental agony and harassment. So who can file complaints under the consumer law? The consumer himself singly or jointly on behalf of other consumers who have the same interest in the subject matter can file a consumer complaint. A registered voluntary consumer association, the central government or the state government, the heirs or legal representatives of the deceased consumer, a child to his parent or legal guardian, and the Central Consumer Protection Authority themselves. Now, it is important to know in which commission you can file a complaint. The limits of pecuniary jurisdiction of the commissions entertaining consumer cases are based on the value of goods and services paid as consideration. So, if the value of such goods and services are up to 50 lakhs, the complaint can be filed with the district commission. If the value is between 50 lakhs and 2 crores, the complaint can be filed with the state commission. If the value of goods and services paid as consideration is above 2 crores, the complaint can be filed with the national commission. Medical and legal services are an indispensable part of our lives. And therefore, it is also thought if and to what extent these services come under the scope of consumer law. The new consumer legislation of 2019 clearly states that a claim will lie against the doctor or the hospital within 2 years from the date of injury in case of medical negligence, and medical negligence amounts to deficiency in service. But medical services provided free of cost or under charity programs are exempted under this Act. Medical services availed at concessional rate fall under the radar of consumer law in India. On the other hand, legal services involve intellectual work done by men. It involves expending time, performing duties, and payment of fees, rather than supply of goods or sale of one's own talent. And therefore, legal services take the color of personal contracts or contract of personal service, which are stated clearly to be exempted under the Consumer Protection Act of 2019. Now, access to consumer courts can be done with or without a lawyer, but it's always ideal to avail the services of a lawyer as the case progresses and in stages of appeal. The consumer legislation of 2019 provides retributive justice in the form of imprisonment and therefore is not entirely a civil legislation. For false and misleading advertisements, the manufacturer, endorser, or publisher will face a fine of 10 lakhs and up to 2 years imprisonment, and which can go up to rupees 50 lakhs fine and 5 years imprisonment for subsequent contraventions. If goods are manufactured containing adulterants or are spurious in nature, they are punishable with a fine up to 1 lakh, imprisonment up to 6 months, suspension of license in the first instance, and cancellation of license in subsequent convictions. If such goods containing an adulterant or are spurious in nature causes an injury to the consumer, then the imprisonment will go up to 1 year and a fine up to 3 lakhs. The license can be suspended in the first instance and cancelled in subsequent convictions. If such injury causes grievous hurt to the consumer, meaning to say if his daily routine is affected for more than 20 days, or if any part of his body is permanently destroyed or impaired, or if his life is endangered, then the punishment will be up to 7 years and fine up to 10 lakhs. If such goods result in the death of the consumer, the term of imprisonment will be a minimum 7 years up to life term and a fine a minimum of 50 lakhs or not a minimum of 10 lakhs. The fee structure for filing complaints is as follows. Up to 5 lakhs, no fees for filing complaints under the consumer law in India. Anywhere between 5 to 10 lakhs, if of case value, the fee will be rupees 200. And if the case value is above 10 lakhs, the fee will be rupees 400. Please note that there is no fee for filing an appeal to the National Commission for complaints registered or orders passed before 20th July 2020 when the Consumer Protection Act of 2019 was enforced. Section 51 Clause 1 states that 50% of the amount ordered by the State Commission must be deposited before an appeal can be filed with the National Commission. Nowhere it is mentioned that this section is retrospective in operation, and therefore, if an order was passed before 20th July 2020 for a future appeal to the National Commission, it can be made by adhering to the deposit condition under the earlier consumer legislation of 1986, in which the deposit cap is Rs 35,000 or more. There are two modes for filing complaints under the consumer law in India. One is the offline mode, in which your complaint must be in writing, and the other is the online mode. If you are availing the online mode, to start with, you can register your complaint on the website of the National Consumer Helpline. And then you need to make a call or send an SMS in the numbers highlighted on the screen before you to register your grievance. After this, you will be provided with a unique ID with which you can track the status of your complaint. You can also install a consumer app or the Umang app on your mobile for this availing of this service. The governmental services available with regard to consumers is the full SMS service. In the number highlighted on the screen before you, you can send an SMS without an internet connection that allows you to get information about the status of your case and also the next hearing date of cases filed with the District Commission, State Commission, and the National Commission. Provided, please take care, the SMS must be in the specified format that is boldly underlined on the screen before you. Before you use or send such an SMS, please take note to access the website given in blue on the screen to get the correct IDs of the State Commission and the District Commissions. The format for sending SMS with the National Commission is displayed on the last part of the screen. There's a laudable initiative by the Department of Consumer Affairs to ease the problems of consumers for filing complaints, and that is the e-Dakil. There is a website for e-Dakil, and once you access the website, you will be provided step-by-step instructions on how to register your grievance. Now, if you have a grievance against misleading advertisements, you can access the GAMA website online. You can file a complaint with the nearest Grahak Suvidha Kendra or a designated voluntary consumer organization, which will then forward your complaint to the online web portal and bring it to the notice of the government. Thank you all for your kind attention. Thank you to the Department of Justice for this laudable initiative, and thank you to the Center for Environmental Education, Research and Advocacy at National Law School for the supportive assistance rendered. Namaste.